Judge Sharp, good morning, Your Honor.
Good morning. How are you?
How are you? Good morning yourself.
Good.
Judge Sharp, good morning, Your Honor.
Good morning. How are you?
Uh-oh.
Good. Is there any reason why this is? Yes. Is it removed now? Can you hear it? Okay. Madam Clerk, this one that was, this one that was just handed to me, is this one retained counsel or is this?
No, that's the one that the jail is supposed to dial into us.
Okay, I'm gonna set this one to the side.
Yes.
Okay.
That was retained, and we also have number 9 is retained. What's his name? Jamal Colbert.
DDC? Is it DDC? DDC?
Yes,
Can you hear me?
Yes, Your Honor.
Can I have Mr. Moore, please?
Copy that, Your Honor.
Stephen Moore. Where's it, Darnell? Darnell. Okay, Stephen. Counsel is present, right? Retained counsel on Moore? Okay, thank you. Mr. Moore, can you state your name for the record, please? Your entire name, including your middle name.
Darnell Moore.
Mr. Moore, you have some outstanding tickets that you have not addressed. So we're going to address those first. Those are misdemeanors. You have a driving while license not valid or improper license. And you have, and that is going to be ticket number, actually SP 120962, excuse me, start all over. SP 1209691. And you also have SP 1209692, and that was no insurance. Both of these are misdemeanors. They carry up to 93 days in jail and or a $500 fine. I am going to counsel enter a not guilty plea for him in these matters. And I am going to set these for hearing. You got a pretrial date of 1/12/2024. You have the right to remain silent. Anything you say can and will be used against you. Do you understand that?
Yes, ma'am.
And on this, you will have a personal bond on both of these matters. Okay, as for your felony case, you have counsel present here for that. You are being charged with these are not the details of.
Back with my appearance on the record.
Sure.
Thank you. Christina McPhail, Scottsdale, P 70739,
Mhm.
appearing on behalf of the city of Baltimore.
Thank you. Counsel, how do you wish to proceed in this matter?
Your Honor, I was going to waive the formal reading of the charges. My client is well aware of them, but I believe he is, but I did have the opportunity to speak with him physically at the detention center,
Mhm.
and I don't believe he was there for all the charges, so I am not gonna waive this formal reading, Your Honor. If the court could oblige us and go ahead and provide that to the defendant.
Okay, as soon as I can find it. Interesting, because I don't see. Where is the complaint? Yeah. Count 1, assault with intent to murder. Count 2, assault with intent to do great bodily harm less than murder or by strangulation. Count 3, weapons carrying concealed. Count 4, assault with a dangerous weapon, felonious assault. Count 5, weapons felony firearm. Count 6, weapons felony firearm. Count 7, weapons felony firearm.
Thank you, Your Honor. Thank you. My client said he-
All right, I will enter a not guilty plea and set this for the next probable cause hearing, probable cause conference date, which is going to be 12/15, and a preliminary exam date of 12/27. Bond conditions will be no guns, no weapons of any kind, no pepper spray, no taser, no brass knuckles, or any type of instrument that can be used as a weapon as it relates to bonds. I'll hear from the people first. Thank you.
Good morning, Your Honor. Samuel, nice to see you.
Good to see you.
Samuel A. Ragland, P 23-157 on behalf of the people. Your Honor, this is obviously a very solid matter. On December 4th, 2023, at approximately 1:24 a.m., the police were called to the address on Cadillac Square, Druck Street, with regard to the shooting. Upon their arrival, they talked to the complainant in this matter, who stated that she had come to the apartment to do her laundry. That her friend, the defendant, was going to let her do her laundry, and that while they were waiting for the laundry, they were drinking. He then has a pole in his apartment, which he got on the pole and was dancing on the pole. He then jumped on the pole and kicked her in the face. With that, he got upset and they started arguing, and he went in the bedroom and got a gun. With that gun, she said, she went downstairs, got her laundry, said, I'm ready to leave. She gets in her car, she goes. He has to open a gate for her to leave. And as he opens the gate, he goes to the passenger side and he spits on her. So she gets upset. Her car gets out of the car and they have a fight. She pulls him down, I think by her hair, on the ground. He becomes obviously more upset. She gets in her car and leaves, and the defendant follows her Well, before she leaves, the defendant shoots at her multiple times with a pistol, striking her in the hand. She then goes to a 7-Eleven store and asks for someone to call 911. The defendant was back at his apartment building. She was transported to the hospital for treatment in stable condition. The police went to the apartment, they found the defendant in the hallway of the apartment building, and they arrested him. Ultimately, and I'm not gonna go through the whole story, Judge, but ultimately they had a search warrant for his apartment. They had a search warrant for 10B, I'm not sure. For apartment 10B as well, because they saw on video that he went into a separate apartment that was empty, but he had a key. And in that apartment, they found the pistol that this man had, that he used to shoot at and wound the defendant. There also is additional video from the Rock Station video, Your Honor, of the incident and of the shooting. So there is evidence that is very instructive of the defendant's actions against the complainant. Your Honor, very serious matter. Shooting a gun, shooting at someone with intent to murder them, shooting in public like that is a danger not only to this victim, to the family, but we're going to ask for $150,000 cash bond. If he's able to post bond, we're going to ask for a GPS tether with phone arrest. Thank you.
Thank you.
Thank you, Your Honor. Briefly, we're just now in receipt of the report, investigative report to actually be able to review it. Your Honor, my client does have a viable defense. One, the court should be advised that the incident took place at his domicile, his apartment, and he's also the superintendent there. So it would be the normal course of business for him to have access to the other apartments and so forth. He's resided there for 2 years. My client also serves security there. So he's specially trained, has multiple certifications in home improvement and security. He is a CPO holder. I'm not sure the status of that CPO currently at the time of this incident. But again, he's handled firearms. I believe that he attempted to want to murder someone, he actually could be as marksmanship type shooting skills. But nonetheless, I think the facts of this incident would play out. My client is stayed there to be able to talk to the police. I believe he made a statement to the officers while present at his place of employment and residence. He's got a flight. He cooperated with officers' commands upon being arrested. In this case, he was actually detained for the 72-hour period, let go, and then once formal charges were issued, they were able to arrest him again at a place where he indicated that typically he would be, so he wasn't running from them, he was cooperative with the process. With respect to any of the other facts, Your Honor, again, those facts that are in dispute, you just again allow the process to play out for that. With regards to the arraignment and issue of bond, again, he's lived at this residence for 2 years, has been in that appointment for 2 years as the superintendent for the building and security without issue. Prior to that, he's an individual 29 years old, a city dweller, a graduate of Clinton Township High School, again with the multiple certifications from different organizations, schools, and so forth. He comes from really good family, from the stock, which is exactly how I know him from more. They retained counsel right away upon the incident. That's us being here. He's likely to appear in court, show up to court. Again, there are some facts and disputes that will have to play out through the process here. And we would ask the court if there was going to be $150,000 bond, that the court would consider 10% provision or lower that bond so that he can actually be available, work with his counsel to address very, very serious charges. He is a father to a 2-year-old who he's a provider for. He pays child support on time. His court orders to indicate that there's no prior history for this individual other than what the court pointed out as those misdemeanor matters. He doesn't have that type of felony history or violent history. on his record. Again, Your Honor, if the court would consider at least a 10% provision, we won't object if there's a GPS tether needed because of the severity of the crime, but that at least be within reason for him to be able to address these matters, help his defense in this case. There's video obviously from the workplace that we are not yet in receipt of. We anticipate we would be able to get that directly from the employer or from the people to be able to review that. There may be some type of exonerating evidence there. Again, that has yet to be seen, but I don't think that, I think he's a strong community member and he has strong employment history, and comes from a good family with a good reputation here in the city as well. And we would ask that we find the more reasonable with the people labs. Again, we will check GPS tether if that's what the court believes is in the best interest of the community and safety for our persons. And of course, respectively, he'll abide by no contact with the victim and any other situation that the court indicates.
Yes,
He
yes.
does not have a CPL license. Apparently doesn't ever had from our records. But the incident, Your Honor, as we stated, is on video.
Yes,
He
I'm
also
aware of
went
that.
ahead and took the license plate off of her car after he shot her. And he took that license plate, which was subsequently found in the apartment, and along with other magazines and things to the gun that he had, Your Honor. So obviously he was trying to, I think, hide himself and not let her be able to be searched or found. But whatever the reason is, shooting someone is the worst thing you can do, I think, to a human being. She's lucky that he is a bad shot or she would be dead. So, Your Honor, you don't just shoot someone multiple times and then think that I'm not trying to kill her. That's what I believe he did, and we're asking for the $150,000 cash and GPS tether to save a full spot. Thank you.
So yes, as a part of the bond conditions, Mr. Moore is to refrain from Malika Williams. Did you hear me, Mr. Moore? You have to refrain from, if in fact you're able to post bond during the pendency of this matter, you are to stay away from Malika Williams at the 21210 Patton Street address in Detroit. Do you understand that? In looking at what's before me, the court takes guns and shooting at someone else very seriously. He allegedly kicked Miss Williams in the face, causing her nose to bleed. Video footage shows Mr. Moore running from an apartment building with a gun, a handgun, and shooting someone multiple times is very serious. By clear and convincing evidence, I think that he is a danger to others, and the court is going to impose a $150,000 cash surety bond with house arrest. Is this an affordable bond or not affordable bond?
This is not an affordable bond. He works as a place of residence, assuming that he keeps his housing and employment there, because that's a condition, obviously, he works there, but he doesn't earn that kind of money again.
So
he's under child support and joint parenting.
So I will set this for a bond redetermination hearing in front of the chief judge for Monday, December 11th.
Thank you, Your Honor. We do appreciate it.
Thank you. 9 a.m. Thank you. Thank you.
Judge, did we get dates on
The initial probable cause hearing date is 12/15, and the preliminary examination date is 12/27. Thank you. You as well.
For your hold on? Justin Benjamin McKinney.
Good morning.
Camera on the women's side is busy.
Pardon me?
No, I think the camera on the women's side is busy. We're not able to.
Okay, let's see. But,
Oh, that's.
yeah.
That one? Nah, she's back. Straight.
Do the paperwork after.
Yeah, you can. I'll just let you know they have to be patient with the paperwork.
Can I give it after the fact? Or do they have to? Let them know they, yeah. Okay. I'm just gonna set these to the side. Thank you.
Want the money? Get it.
And the next retained matter is Jamal Colbert. Mr. Colbert?
Come on, Cole. Come on, Bo. I'll step on the black line.
I'm gonna just keep it
Yeah,
together.
please.
Okay.
I gotta get it. This is this one. I'm sorry.
It's okay.
Okay.
We'll put everything to the side.
Yes, no,
And
yeah,
then put everything to the side and have it in stack for you.
Please.
Stack.
thank you. Please state your full name for the record, including your middle name.
Jamal Terrell Colbert.
Mr. Colbert, you are here for, you're being charged with assault with a dangerous weapon, count 1, count 2, assault with a dangerous weapon, felonious assault, count 3, assault with a dangerous weapon, count 4, driving reckless. Your counsel is here in the courtroom. Counsel, please state your appearance.
Good morning, Edward Taylor, T 57166, appearing on behalf of Mr. Cole.
How would you like to proceed?
And you waive the formal reading of information.
All right, so your probable cause conference date will be December 15th, 2023. Your preliminary examination date will be December 27th, 2023.
May I address bond?
Yes, 1 second. Yes, go ahead and address bond, and I will give bond conditions after you're done.
Well, to be honest, this is Mr. Colbert's first life resident in Detroit. He has good community ties.
Go. State your appearance, please.
Samuel A. Ragland, 157 on behalf of the people, Your Honor. Now, it's a very assaultive matter. The complainant was driving down M39 when the car in front of him, pulled in front of him, and then tried to run into him to barricade. Not once, but at least twice. The complainant then got off of the freeway, and they followed him. He followed him off the freeway to the corner, probably. That's my assumption. And then when he got back on the freeway, the defendant couldn't get on the way that the complainant did. The defendant was picked out for total lineup, Your Honor. He had the license plate of the vehicle that was trying to run him into the wall. The license plate went to a vehicle that was owned by the defendant. It was the one that he was driving at the time. So they were able to find cell phone information where the defendant was at the time of this incident, which was on M39. They were able to produce the block system of cameras capable of reading license plates that the defendant, they could see the defendant's vehicle was at M39 at the time of the alleged assault. They also were able to observe use a search engine that determined what the conducting preliminary mapping of the defendant and his car. So there's not too much question about what happened, and this defendant was responsible for it. So, Your Honor, we were going to be asking for a $10,000, 10% bond, GPS tether with home arrest.
Counsel, does your client work?
He does, Your Honor.
Where does he work?
Mr. Goldberg, would you tell us where you work in your hours, please?
Hear you?
Where you work in your hours?
Work at AAA.
What are your hours and what day?
Monday, Tuesday, Wednesday, Friday, Saturday, 6 a.m. to roughly around 3:30 p.m.
What do you do there?
Towing.
I take it that Mr. Colbert did not know the complainant.
I don't believe so, Your Honor.
They don't know each other.
No, Your Honor.
Does he have any, is there any prior criminal history here? No.
No, Your Honor.
So this court is going to impose a $10,000, 10% cash bond, in addition to a GPS tether, allowing him to go to and from work.
Thank you, Your Honor.
Thank you. You as well.
Next man.
Say it full back again, bro.
Justin Benjamin McKinney.
I am so sorry. What you need for me to do?
Am I bothering you?
Mm-mm. What you need for me to do?
Just write the bond. You don't have to do
I forgot.
all of that. It's,
Shoot.
yeah, you don't have to write on every sheet. You
Okay.
can fill that in later, but just on the first one.
Which one is this one? This is Cobra, so I just did, so it's 10,000, 10%. So what do you want me to
10%, so
Yeah.
you can circle the 10%.
do? And do 10,000?
Mhm. And if you have extra bond conditions like GPS, you can just screw it in there. And then
What else you need? You
This
can
is-
keep doing it afterwards if you want, if this makes it easier for you.
if this is, I mean, we just need the bond
Okay.
amount and extra conditions. And if you want to do the sign later, you can do that later.
Yeah.
And then, and this is usually how they start off.
Yeah. I don't know.
They
Nervous.
read the way we're reading that would take you time or read the charge.
I'm skipping it all. What's your name, sir?
Justin Benjamin McKinney.
All right, calling case number 23044564001, the People versus Justin McKinney. State your full name, including your middle name.
Justin Benjamin McKinney.
All right. All right, Mr. McKinney, you are here for count 1, domestic violence. Your attorney is here on your behalf. Counsel, state your appearance.
Right, Marat, P3665. I'm here, Mr. Justin McKinney, judge will waive the reading. Mr. McKinney stands reading to the findings, right?
All right, I'm going to give you a probable cause, no, I'm sorry, a pretrial date of December 8th, 2023 in front of Judge Garrett. All right, bond conditions, you are to refrain from having any contact against the complainant.
Your Honor, I'm so sorry if I may.
Sure.
I think the date you gave us was December 8th. I think it was-
That is correct. You're correct about that. That's what's actually on here. Madam Clerk? Sure. Sorry. I have a pretrial date of December 8th, and obviously that can't be correct.
That's the judge here.
That's today.
That's correct.
Oh my goodness.
12/12, December 12th, 2023 in front of Judge Garrett. That'll be your next court date. Interestingly enough, this is interesting. Madam Clerk, I just want to say that. That's
it, right? So investigative report, and that's all that we have.
I don't have the complainant's information on here.
I'm sorry.
The complainant's information. I don't have her information.
Oh, the,
You understand? Unless I'm missing something, I don't see that. There. So, Mr. McKinney, in terms of your bond condition, you are to refrain from having any direct or indirect contact with Alexis Bailey. That means no phone conversation, no in person, no notes, no third parties are to be used to try to communicate with Ms. Bailey. So in terms of bond, counsel, what are you requesting the people?
Judge, good morning. Privilege to see this morning Stevenson on behalf of the people, P71917. Just to expedite this process, Judge, it appears as though this is a reach. Believe it or not, it's a 21 misdemeanor EV. This defendant was arraigned on this matter, this incident date in May of last year. The complaining witness failed to appear earlier this year at exam. It was dismissed, and it appears as though it's a reissue. At the arraignment in 2022 in May, I believe it was the Honorable Magistrate Lawyer who gave a $10,000 personal bond. We would just be asking for that $10,000 personal to be imposed.
No objection.
All right, so there will be a $10,000 personal bond in this matter. Thank you, Mr. McKinney. You can step aside.
Thank you, Your Honor.
Thank you.
Face the camera, say your full name.
Kamaria McCann.
One second.
My little brother.
Here. What's your name?
Say it again.
Kamaria McCann.
Okay, calling case number 230-456-3501, the people versus, is it Kawan McCann? I can't hear you. I think you're muted, DDC.
There you go, y'all.
What's his name?
Okay,
Kamaria McCann.
all right, so you're here today, sir, for count one, assault or assault and battery. You have counsel present here on your behalf, counsel. Your appearance.
3665 on behalf of Mr. Kamaria McCann. We waive the reading. Mr. McCann stands. The judge has been advised of his constitutional right.
All right, so there's going to be a pretrial date set for February the 12th, 2024 in this matter in front of Judge Bryant. Let's address the issue of bond, counsel.
Thank you, Your Honor. This is not a case. It happened in September of this year. Allegedly, because he was being escorted, he was, I guess, creating some type of disturbance in the school that he was going to. He didn't like the fact he was being escorted out, ends up throwing a punch at the security officer. Judge, it's charged as a misdemeanor, 93 days. If Your Honor already handled the no contact, at least through the pendency of this, we're not going to object to a personal bond here.
Judge, personal bond is appropriate. No progress here. No pending matters. No objection. No contact with complaining witness. My client is stable residence, has a life resident here in the city of Detroit. No cases, history, no criminal history. Just started working at Applebee's. I'm asking for that personal bond.
Okay, so the complainant Nehemiah Thomas. So
We would be asking, Your Honor, just no contact if he's working and not attending the school at this point, just no contact with the individual or the school, at least through the pendency of this case.
No objection.
okay, so there's going to be a personal bond. Did you just say personal bond in this matter?
Yeah, personal bond in the amount of either $5,000 or $10,000, Judge.
Personal bond in the amount of $5,000. You're not to have any contact with the complainant in this matter. And also in terms of staying away from, what did you, the people are requesting?
I'm sorry, Judge. Yeah, we were just requesting no contact with the complainant in this matter or the address, which is the school. It's that, I believe it's the 9100 Gratiot Avenue.
And the 9100 Gratiot address. Okay, thank you. You can step aside.
I don't have a problem with him asking a question. Can we call him back?
Can we have him to come back, please? He has a question. It may be addressed to his counsel.
Yes, so he said that he was gonna drop the charge because he wanted me to re-roll back in school.
Anything you say can and will be used against you, and your counsel is advising you not to say anything. And so you may want to get in touch with your counsel after you are released to have that discussion.
Thank you, Your Honor. I have nothing further.
Yeah, thank you. I have to do this. Yeah, right.
How far are you?
State your name for the record, please.
Emil Upchurch.
Emil Upchurch. Say Emil Upchurch?
Yes, ma'am.
I don't think that. I don't think I have Emil Upchurch.
Oh, I'm sorry, I didn't.
You had it. All right, so you have some misdemeanor matters that you have failed to address in terms of a ticket. Calling case number U 92085512. This was let's see. The ticket is not here. A narcotic drug violation. So I'm going to set aside the warrant and enter a not guilty plea on your behalf. Your pretrial date will be January 11th, 2024, in front of Judge Jones. You have the right to remain silent. Anything you say can or will be used against you. If you can't afford an attorney, the court will give you an attorney. Going to your felony matter. This one is okay, you have a domestic violence issue. Calling case number
Corner of that register act, what you're holding in your hand? It's the case number 05.
Right, I was getting ready to call.
Okay.
Calling 05-057-34001. The People versus Emil Upchurch. Again, state your full name for the record.
Emil Upchurch.
Okay. You have counsel here present in the courtroom, counsel, if you state your appearance.
Sorry. Driver on PA 3665, on behalf of Mr. Upchurch, we waive the formal reading. Mr. Upchurch stands to you. He's been advised of his rights.
All right, a not guilty plea has been entered on your behalf, and we need a correct court date, Madam Clerk.
It'll be December 12th.
December 12th. Okay, your next date will be December 12th in front of Judge Garrett, 2023. All right, as to the issue of bond, I will address bond conditions after. I will hear from the people.
Thanks, Judge. It is a 2005 matter. It's being charged as a misdemeanor, but for the fact this is approximately 18 old, I think I may have treated it differently in terms of how I approached bond. The defendant at the time was on probation. He was on probation for a controlled substance offense. He was only on probation as a direct result of multiple violations, which that probation extended to 2008. Ironically, this defendant just resolved a failure to pay felony matter over in Frank Murphy yesterday. So we had a defendant who subsequently was getting involved in things following this incident. However, with all of that being said, I haven't found any assaultive type allegations and or convictions since this offense. And as a direct result of that, I'm not going to be objecting to a personal bond at this point.
There's no assault history here. That child support matter was dismissed because it's last year's payment. Personal bond should be appropriate. I'd ask the court for that. With regard to the complainant witness, this is a former girlfriend. This was a long time ago. He doesn't indicate that they're still close. I think no assault might be appropriate here, but I believe that in the court's discretion. I'm just looking for personal bond.
Okay, in terms of bond conditions, Mr. Upchurch, you are to have no contact with the complainant. That means no phone calls, no direct contact, indirect contact, no social media, nothing. And the court is going to impose a personal bond. You can step aside.
We would just be asking if
Mr. Donovan,
Oh, I'm sorry, excuse me. $5,000 personal, thank you.
thank you, Your Honor.
Thank you.
Face the camera, say your full name.
Marquise Criego.
Marquise. All right, calling case number 23060333601, the People versus Marquise Holcomb.
Samuel E. Reagan, for the people, Your Honor.
Driver on P3665 on behalf of Mr. Marquise Holcomb, we waiting for a reading. Mr. Holcomb stands mute. He's going to advise his rights.
All right, so a not guilty plea will be entered on your behalf. Your next court date will be December the 20th, 2023 for your probable cause conference, and December 27th, 2023 in front of Judge Robbins for your preliminary examination. Before I address bond conditions, can I address the issue of bond, please?
Yes, Your Honor. This defendant was cooperative. He former CPL license holder, no criminal record. So we're asking for $10,000.
Okay, so as part of your bond conditions, you're just not to have any weapons during the pendency of this case, as well as any thing that can be used as a weapon, taser, brass knuckles, and so forth. And so your bond will be $10,000 personal. Thank you. Thank you. You can step aside. Care of it. I haven't done anything. No. I'm gonna do it after. Sorry. State your name, please.
Seth Mitchell.
All right, calling case number 23060333701, the People versus Seth Mitchell.
Samuel E. Reagan, for the people, Your Honor.
Driver on P3665 on behalf of Mr. Seth Mitchell, we waive the reading. Mr. Mitchell stands mute. He's been advised of his rights.
All right, a not guilty plea will be entered on your behalf. Your next probable cause conference date is December 15th, 2023 And your preliminary examination date will be December 20th, 2023 in front of Judge Sabri. In terms of bond, before I impose bond conditions, counsel?
Yeah, people are gonna ask for $10,000 personal bond. The defendant though was, on foot when he was observed, by the defense, by the police. He was not cooperative. He lay on the ground. They couldn't search him. He was arrested. He's only 20 years old. And we hope that this will be the last time he's involved.
No objection to personal bond, Your Honor. My client doesn't have any prior criminal history. He's gainfully employed, has a stable residence in the state. We would ask the court for that personal bond.
Okay. I'm going to impose a $10,000 personal bond. Your conditions, you're not to have any weapons of any kind, no guns, no tasers, no brass knuckles, nothing like that. And I hope that this is your last contact with the system. Step aside. Thank you.
Next man.
State your name, please.
Donnie Lamont Smith.
Did you say Maxwell? Did you say, state your name again?
Donnie Lamont Smith.
This is Christina Bridges. Okay. All right, Mr. Smith, you have several other misdemeanor matters that you have failed to handle. And there are warrants in these matters. And so I'm going to set aside the warrants. I'm calling ticket number, actually. Where's the ticket number? 264980. This was for no operator's permit. P11688920. Improperly displayed plate, improper plates, no insurance misdemeanor. P11699197. Driving while license not valid or improper license. I'm going to set aside the warrant in these matters. Enter a not guilty plea for you. And set this for a hearing date of
Disregard the email. Disregard.
January 11th, 2024, in front of Judge Archer. You have the right to remain silent. Anything you say can or will be used against you. If you can't afford an attorney, one will be appointed for you. Do you understand what I've just said to you?
Yes.
Okay. Here. Calling case number 23060333801. Up, wrong, nope. Take that. That's not correct. Wrong case number. I apologize. Those two were put together and these go with that. Excuse me, but his A1 matter. I don't see it. It's not attached to this. This is Jalen. This is somebody else. This is somebody else. Unless I'm missing it, where's his A1 matter? Mm-mm. It's tickets, right?
Yeah,
Right.
so what are you looking for?
The matter that he's here for on his,
Felony?
yes.
Your name is,
It's the one with the two people. That one. He's,
This one?
yes,
Oh,
he's-
it's
he's-
below it.
He's
Here.
number 2.
Okay. Okay, calling case number 23060333802, the people versus Donnie Lamont Smith.
Judge, good morning. It's a pleasure. Steve Benson for the people, P71917.
Ryan Marab, PA 3665, on behalf of Mr. Donnie Smith, you may be reading. Mr. Smith stands mute. He's been advised his right.
All right, so I'm going to enter a not guilty plea on your behalf. You will have a probable cause conference on December 15th, 2023, and a preliminary examination December 27th, 2023, in front of Judge Giles. As for the issue of bond, before I impose bond conditions.
Thank you, Your Honor. Respectfully, we're going to be asking for $1 million. We're also going to be asking if the defendant were to post that $1 million, which we would be asking for cash, monetarization, as well as home confinement. Your Honor, I'm going to tell you the reasons to support the cash, and then I'll just briefly get into the allegations. This incident, Judge, and the behavior specifically of this defendant, they clearly show that this defendant is a danger to the multiple complainants. There was only one listed on the investigator's report in terms of identification. There were actually 2 complainants here. Further, it was this defendant who gave an order to the other defendant in this matter to kill the complainants. That order to kill was unsuccessful because the complainant who was shot survived. And Your Honor, as a direct result of that, the people are concerned that based on the fact that that individual stayed alive, that order to kill was unsuccessful, we feel as though those complainants are at a great risk of harm by this particular defendant. And that based on the nature of the offenses, we are requesting that $1 million. He's also a HAB 4 judge. In this particular matter, and Your Honor, I know that the investigative report was quite extensive, but we have a shooting allegedly by this defendant that was motivated as a direct result of this defendant believing that complainant 1 and complainant 2 were informants to the feds. Why? Because his drug house that he was selling drugs from was raided, and he ended up seeing both complainants talking to the police. So as a direct result of that, this allegedly, Judge, was retaliation. As we see in the investigative report, the defendant, as well as an additional defendant, and the individual who subsequently got shot entered a residence. This defendant, as well as the other defendant, ended up tying up the individual they came into the house with, who was complainant 1, as well as complainant 2, who was the girlfriend of the homeowner. This defendant, with the other defendant, ended up making those 2 individuals that were tied up go down into the basement. This defendant ordered the second defendant to kill the complainants. wherein defendant number one ended up shooting complainant number one. That shot penetrated that complainant's scrotum. Subsequent to the shooting, judge, this defendant, as well as defendant two, ended up stealing the homeowner's vehicle. Subsequently, they were arrested, and judge, multiple people within that residence have positively ID'd this individual as the individual who was at that house who ordered the shooting. Judge, based on the allegations, based on the nature of the offenses, based on the motivation, based on all of the particulars of this case, we feel as though this defendant is a substantial danger, not only to the complainants in this matter, but to the community as a whole. And therefore, judge, respectfully, we're going to be asking for that $1 million cash bond with monetarization and home confinement.
Your Honor, on behalf of Mr. Smith, I would argue that he's 44 years old. He's been a life resident here in the city of Detroit his whole life, where he has a stable residence with his mother. He has 3 children. He's not employed at this time, Your Honor. He's not able to post any monetary bond, let alone $1 million with the tethers that we can do anything. Judge, with regard to Mr. Smith and some of the allegations that were read into the record, I have to argue them. I heard people mention a lot about order to kill, this order to kill. My client is charged because there's a statement made against him that he made a statement, that he told somebody to shoot somebody, and that the allegations don't say that he tied anybody up. The allegations say that he told people to tie each other up. It's all statements about his statements. That's why Mr. Smith is here today, Judge. Statements about his statements. Now, I understand it's an assault with a murder charge. It's a unlawful imprisonment charge. These charges typically, courts do issue high-cash bonds, but to issue a bond in anywhere near $1 million is absolutely depriving my client of his right to a reasonable bond. Judge, we talked about identification. Who made these identifications? The complainant and a boyfriend of another complainant? Excuse me.
But not. They're saying we're not, but it says we are.
Yeah. Yeah, says we're lying. Yeah, you're correct.
Thank you.
I'm sorry to interrupt.
Okay,
You're good.
Okay.
so Judge, I was
I'm
just
sorry.
continue.
No, you good. Any questions? Okay.
That's the last one.
Good. Okay. I'll be right here. I'll be right there for a few minutes and back upstairs. You need anything? Thank you.
Okay, proceed. I'm sorry.
Thank you, Your Honor. And this isn't the time to litigate this case for this investigator's report. We don't have discovery. We don't have anything. We have the police officer side and any witness that the police officers interviewed side. We don't have my client's side. We don't know what happened. But what we do know is if we take all these allegations, no matter what they are, it's their statements about my client's statements. It's not my client who's alleged to have shot him. That's not what this case is. That case would warrant a high cash bond. This is a case about a statement that my client may or may not have made, and if he's presumed innocent, and we're not presuming guilt at this stage, we're gonna give this guy $1 million of a bond because of a statement made about his statements. Now, again, these are serious charges. I get the court has a job to do, it has to protect the community. I understand. So what I'm gonna ask the court to do here, while considering that he has no assault and criminal history, this isn't anything that he's ever given, no assault convictions that I'm aware of. He's not on any probation or parole. I'm gonna ask the court to consider a reasonable bond because he's not employed, because he has a stable residence. I'm gonna ask the court to consider a GPS confinement as the people requested, but Judge, there's no point in issuing a GPS tender if we're gonna give $1 million cash fine. He can't post it near that. Additionally, Your Honor, I'm looking at some of these prior criminal convictions, and maybe the people will correct me if I'm mistaken. I don't see anything in the last 10 years. I don't see anything at all. So does Mr. Smith deserve a chance to be presumed innocent and get a reasonable bond? I would argue yes. And as for a reasonable bond, the GPS tender will provide.
And Judge, just if I may really briefly, it's really funny that defense counsel ended up bringing up the prior convictions which goes towards the motivation here. The defendant owning a drug house, being in fear of the complainant, speaking with the federal agents or police officers. But for this defendant, it could be argued this incident would have never occurred. And quite honestly, Your Honor, if I could have asked for remand, I would have.
And
So-
Your Honor, just to respond briefly, sorry. He's not charged with this. He's not, where's the drug house charge? Where's the witness intimidation charge? There's a process for this stuff. Doesn't be a problem with false finding. This wasn't a police center. Right? He said he stole the complainant's car. Why is he charged with receiving concealed motor vehicle? We get folks all the time. Why is he charged? Let's give him the benefit of his presumption, Your Honor, and give him a reasonable bond, which is yes, fine.
Well, okay, the court has listened to the arguments, and these allegations are very, very, very serious. I mean, there are 18 counts here, and we have a victim who's been shot.
Complaining witness, Your Honor.
Complaining witness has been shot, but still no less shot.
Not by my client.
I'm going to impose a $1 million cash bond with a GPS tether. I do determine, I'm sure that this is an unaffordable bond. So counsel, you can address that in front of the chief judge for a redetermination hearing on Monday, December the 11th at 2023 at 9 a.m. I would imagine that based upon your statements that he can't afford this bond, so there are no other conditions at this time.
Thank you, Your Honor.
Thank you. So it's the co-defendant. Oh, she's a female. Yeah, I saw that. So we'll just have to wait for hers. I'll put this aside.
Say it again loud. Jalen Jamon Miller.
All right, calling case number 230-6034001, the People versus Jalen Miller.
Your Honor, good morning.
Good morning.
Steve Benson for the people.
Right for P3665, Your Honor, I apologize. Mr. Miller is, Your Honor, right around P3665, we have Mr. Miller waiting for the reading. Mr. Miller stands duties to advise of his rights.
All right, I'm going to enter a not guilty plea on your behalf. Your next court date will be December 20th, 2023 for a probable cause conference, and December 27th, 2023 for a preliminary examination in front of Judge Robbins. In terms of bond conditions, I'm going to require that you refrain from having any handguns, any guns, any type of dangerous weapons, brass knuckles, taser, and so forth. As to the issue of bonds, counsel, you will have a personal bond, 5,000 personal. Thank you. You can step aside.